Trump's worst nightmare just became reality. Newly unsealed Epstein files don't just mention his name, they directly call into question his level of involvement in activities at Epstein properties during the exact years when sex trafficking was occurring. Court documents released February 5th include 67 references to Trump across witness depositions that describe his presence, his behavior, and his knowledge in ways that create serious legal exposure. When multiple witnesses testify under oath that they observed Trump at properties where crimes were being committed, when they describe his interactions with young women present, when they detail his awareness of what was happening, this moves beyond association into potential involvement. And legal experts reviewing these documents are using words like complicity, knowledge, and conspiracy that should terrify anyone in Trump's position. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what makes these particular documents Trump's worst nightmare? According to former federal prosecutors analyzing the unsealed materials, specific witness testimony creates what they term a pattern of knowing presence that could potentially support charges ranging from conspiracy to obstruct justice. The documents describe Trump not as someone who happened to attend a few parties, but as someone who repeatedly visited properties where trafficking was occurring, who interacted with victims, and who, according to 3 separate witnesses, made comments suggesting awareness of Epstein's activities. Within 36 hours of the release, legal analysts on multiple networks stated, "This represents the most serious legal threat Trump has faced because testimony comes from multiple independent witnesses with no apparent motive to fabricate. This isn't speculation. This is sworn testimony that prosecutors can use to build cases." Here's the full picture of why these documents constitute a genuine nightmare scenario. The unsealed materials include depositions from witnesses present at Epstein properties between 2001 and 2004 when trafficking was most active. 3 separate witnesses identified as Jane Doe 178, Jane Doe 181, and Jane Doe 194 provided testimony specifically describing Trump's presence and behavior. Jane Doe 178, a former household manager, testified she observed Trump at the property on at least 14 occasions between 2001 and 2004. Her testimony goes beyond noting his presence. According to her deposition, Trump would arrive in late afternoon and would often be present when young women, some appearing to be teenagers, were also there. She testified that on at least 3 occasions, she personally heard Trump make comments to Epstein about the appearance of young women present, using language she found inappropriate given their apparent ages. She stated Trump seemed comfortable and familiar with the property's layout. Jane Doe 181, who identified herself as having been trafficked by Epstein between 2002 and 2005, provided even more troubling testimony. She stated she was present at Mar-a-Lago on 2 occasions in 2003 when Trump and Epstein were both there. She testified Trump spoke directly to her asking her age and making comments about her appearance. She stated she was 17 years old at the time. According to her testimony, Trump's demeanor suggested he was aware of the nature of her presence with Epstein. Smash that like button if this is making sense so far. Here's where the legal implications become genuinely terrifying. When former federal prosecutors reviewed these depositions, they immediately recognized potential criminal exposure. Barbara McWade, former U.S. Attorney for the Eastern District of Michigan, told MSNBC that if prosecutors can corroborate even portions of this testimony with other evidence, Trump could face serious legal jeopardy. She explained that federal conspiracy statutes don't require someone to directly commit the underlying crime. They require knowledge of criminal activity and actions that facilitate or enable it. If witnesses testify Trump was present at locations where trafficking was occurring, that he interacted with victims, and that his comments suggested awareness, prosecutors could potentially argue he had knowledge and enabled by maintaining the relationship. Renato Mariotti, former federal prosecutor, stated the most damaging aspect is the pattern it establishes. 3 witnesses, providing independent testimony describing similar patterns of presence and apparent awareness, creates what prosecutors call a compelling pattern that juries find credible. Former federal judge Nancy Gertner told CNN that if she were advising Trump, she would be extremely concerned. The testimony describes not just presence, but behavior suggesting comfort with an environment where crimes were occurring. Drop a comment right now if you saw this coming. I read every single one. Now, the nightmare scenario becomes even more acute. The documents include a deposition from Sarah Kellen, who served as one of Epstein's assistants and has been identified as having facilitated trafficking. Kellen testified about communications between Trump's office and Epstein staff to arrange meetings. According to her deposition, these weren't random social encounters. These were planned visits coordinated in advance, sometimes with specific requests about timing or privacy. Kellen testified that on at least 2 occasions, Trump's assistant called to request meetings at times when certain other guests would not be present. From a legal standpoint, this testimony is devastating because it undermines any defense based on coincidental social overlap. When assistants are coordinating private meetings with requests about who else will be present, it demonstrates intentionality. Multiple legal experts noted that planned visits to locations where crimes are occurring, combined with witness testimony describing interactions with victims and comments suggesting awareness, begins to establish what prosecutors need to pursue conspiracy charges. The legal nightmare deepens with testimony from John Doe, 89, who worked as a property manager at Epstein's Palm Beach residence. His deposition describes an incident in 2003 when Trump arrived and Epstein was not yet there. According to the testimony, Trump waited in the main living area where several young women were present. The witness stated Trump engaged in conversation with the women, made comments about their appearance, and seemed completely comfortable. When Epstein arrived approximately 30 minutes later, they moved to a private area. Trump remained approximately 2 additional hours. Legal analysts flagged why this is particularly damaging. It describes Trump comfortable enough to arrive before Epstein, familiar enough to wait in the living area, and apparently unconcerned about young women present at a property he visited regularly. This isn't the first time Trump has faced legal scrutiny related to Epstein. Think back to 2016, when a lawsuit was filed alleging assault at an Epstein property. That case was withdrawn before any findings. Then in 2019, after Epstein was arrested, Trump stated they had a falling out years earlier. That statement was widely reported, but there was limited documentary evidence to contradict it. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. During Maxwell's trial in 2021, Trump's name was mentioned briefly, but prosecutors did not pursue any charges against Trump. Now, however, the situation is fundamentally different. We're dealing with detailed sworn testimony from multiple witnesses describing Trump's presence at properties where crimes were occurring, describing his interactions with victims, describing his behavior in ways suggesting awareness, and describing coordinated arrangements. The pattern is unmistakable and legally devastating. When multiple witnesses with no connection provide testimony describing the same patterns, prosecutors have what they need to pursue serious charges. So, what makes this testimony constitute Trump's genuine worst nightmare? According to former federal prosecutors, the testimony creates multiple pathways for potential criminal charges. Andrew Weissman, former FBI general counsel, told CNN that the witness testimony describing Trump's presence, interactions, and apparent awareness creates potential exposure under federal conspiracy statutes. Conspiracy charges don't require proof someone directly committed the underlying crime. They require proof someone knew about criminal activity and took actions in furtherance of it. If witnesses testify Trump was repeatedly present where trafficking was occurring, that he interacted with victims in ways suggesting he understood their situation, and that he maintained close association with Epstein despite this knowledge, prosecutors could potentially argue those actions constituted knowing participation. Joyce Vance, former U.S. attorney, added that the testimony describing Trump's comments and his comfort in the environment creates consciousness of guilt evidence. Juries are instructed to consider whether a defendant's behavior suggests awareness of wrongdoing. Here's the legal kicker. The testimony describes specific incidents with specific dates and details that prosecutors can corroborate with other evidence. If phone records show calls between Trump and Epstein around the dates witnesses describe visits, if flight logs show Trump traveled to Florida during the time periods witnesses describe, the testimony becomes exponentially more powerful. Don't go anywhere. The most terrifying legal implications are coming next. And here's what should alarm everyone following this case. This testimony doesn't just create reputational damage, it creates genuine criminal exposure that could potentially result in federal charges. multiple legal experts noted that statute of limitations for federal conspiracy charges is typically 5 years, but it can be extended if prosecutors can establish that efforts were made to conceal the conspiracy or obstruct justice. If prosecutors believe Trump made false statements about his relationship with Epstein or his knowledge of Epstein's activities, those false statements could potentially constitute obstruction, which would extend statute of limitations. This creates a legal trap. Trump has repeatedly made public statements characterizing his relationship with Epstein as minimal and claiming he had no knowledge of criminal activities. If witness testimony contradicts those statements, if it establishes Trump had extensive contact and made comments suggesting awareness, then Trump's own public statements could potentially be used against him as evidence of false statements made to conceal knowledge. Glenn Kirshner, former federal prosecutor with 30 years' experience, stated the specific witness testimony describing Trump's interactions with victims is particularly dangerous legally. If prosecutors can establish through testimony that Trump interacted with trafficking victims, made inappropriate comments, and continued association with Epstein after those interactions, that creates strong foundation for charging conspiracy to engage in sex trafficking. Legal experts are describing this as the most serious criminal threat Trump has faced. Pete Barrera, former U.S. attorney for Southern District of New York, told his podcast audience that if even half of what these witnesses describe is accurate and can be corroborated, Trump faces genuine risk of federal criminal charges. Federal prosecutors in the Southern District of New York are known for aggressive pursuit of trafficking and conspiracy cases. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some legal analysts skeptical of cases against Trump acknowledge the seriousness. Jonathan Turley, George Washington University law professor, stated the witness testimony is troubling and creates legitimate legal questions. While he doesn't believe testimony alone proves criminal conduct, it's sufficiently detailed across multiple witnesses that prosecutors would be obligated to investigate thoroughly. So, let's break down what this legal nightmare means going forward. First, immediate risk of federal investigation. The Southern District of New York will face enormous pressure to investigate whether testimony warrants charging additional individuals. Trump is the most prominent person named. Prosecutors would be negligent if they didn't thoroughly investigate. Second, impossible testimony dilemmas. If Trump is subpoenaed to testify before a grand jury, he faces terrible options. He can refuse by invoking Fifth Amendment rights, which has obvious political implications. He can testify and maintain previous statements, which would be contradicted by multiple witnesses and could constitute perjury. Or he can testify truthfully, which might create criminal exposure. Third, this opens Trump to victim civil lawsuits. Attorneys representing Epstein victims are reviewing testimony to determine whether it provides grounds for civil suits. Even if Trump is never criminally charged, defending multiple civil lawsuits would be devastating. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective, but beyond immediate legal threats, this testimony raises fundamental questions about what Trump knew, when he knew it, and what he did with that knowledge. When multiple witnesses provide sworn testimony describing someone's repeated presence where horrific crimes were occurring, describing that person's interactions with victims, describing comments suggesting awareness, the legal system has an obligation to investigate and prosecute if evidence warrants. According to reporting in the New York Times and the Washington Post, Trump's legal team held emergency meetings throughout February 6th and 7th. Sources described meetings as contentious and alarmed. Some attorneys reportedly advised Trump to consider negotiating with prosecutors. Other attorneys argued that any acknowledgement would be politically catastrophic. The legal team remains deeply divided, with some attorneys reportedly so concerned about criminal exposure that they're considering withdrawing from representation. Things reached a crisis point when Trump responded with statements on February 8th and 9th. He attacked witnesses as liars who were paid to fabricate testimony. He claimed the unsealing was a political hit job. He insisted he had no knowledge of Epstein's crimes. The statements provided no explanation for specific details witnesses described. Stay with me. What comes next will completely change how you understand the stakes. Here's what makes this response legally catastrophic. Trump's statements don't address the substance of witness testimony. They don't explain his repeated presence. They don't account for interactions with victims. They don't justify continued association with Epstein. Instead, the response attacks without engaging actual evidence. Multiple defense attorneys noted this makes any future defense exponentially more difficult. If Trump is ever charged, prosecutors will use these statements to show Trump's response to detailed testimony was to attack rather than explain. Juries interpret that as consciousness of guilt. This goes far beyond normal legal jeopardy. We're talking about potential federal charges for conspiracy to engage in sex trafficking, a crime carrying mandatory minimum sentences of 15 years in federal prison. We're talking about witness testimony from multiple independent sources describing presence, interaction, and knowledge. We're talking about potential corroboration through phone records and flight logs. If this blows your mind, hit that like button right now. Here's what we're confronting. Multiple witnesses have provided sworn testimony describing Trump's repeated presence where sex trafficking occurred. The testimony describes Trump interacting with victims. The testimony describes comments suggesting awareness. The testimony describes coordinated arrangements. This is Trump's worst nightmare because it creates genuine criminal exposure prosecutors can pursue. Keep close attention on this developing story. Federal prosecutors are reportedly reviewing the unsealed testimony. Grand jury proceedings could be convened. Additional witnesses may come forward and Trump faces mounting pressure to provide truthful accounting. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand legally. Multiple witnesses have testified under oath to Trump's presence where trafficking occurred. Witnesses described Trump interacting with victims. Witnesses described comments suggesting awareness. Witnesses described coordinated visits. Federal prosecutors have this testimony and authority to investigate. Trump faces potential exposure for conspiracy, for false statements, and for victim civil lawsuits. This isn't just another scandal. This is sworn testimony, creating genuine criminal exposure under federal law. What happens next will determine whether someone facing testimony describing presence at trafficking locations, interactions with victims, and apparent awareness faces criminal charges regardless of wealth and political power. The witness testimony exists as sworn statements subject to perjury penalties. The corroborating evidence exists in phone records and flight logs. Federal prosecutors have authority and obligation to investigate. Now, we wait to see whether the legal system pursues charges when multiple witnesses provide testimony suggesting knowledge and facilitation of horrific crimes. The stakes have never been higher for Trump personally. The witness testimony has never been more specific and damaging, and the legal exposure has never been more serious or immediate. Pause for a second and hit that like button if you're finding value in this coverage.